So for our second panel this afternoon, appearing as an individual, but certainly an individual who knows a lot about the subject matter covered by Bill C-23, Pierre Kingsley, who's the former Chief Electoral Officer of Canada. Welcome, sir. Good to have you here, and I'll give the floor to you for an opening statement.
Thank you, Mr. Chairman. Honorable Sénateur.
Honorable Senators, I want to thank you for inviting me to appear here before you with respect to Bill C-23, a very long and complicated bill. Senator Joyal expressed his hope that I would reappear here when a few years ago, when I left the position in 2007. I can tell you that I'm only going to be speaking for about 3 minutes' time. I'm not going to go over the deposition that I made at the Standing Committee on Procedure in the other place. The Clark and I agreed that it would suffice for me, it would be sufficient, rather, for me to go over a few main points.
Consider positive elements in the bill concerning robocalls, the registration of service providers, and the retention of records. The significant increase in fines to $50,000 and $100,000, depending upon the infraction. The graduated and significant reduction in the reimbursement of campaign expenditures in cases of overspending of the limit. The fourth day of advance polls. The Quebec election has just demonstrated the popularity of that. The reformed schemes for loans and unpaid claims. The legalization of the Advisory Committee of Political Parties. And the requirement for statutory interpretations and advanced rulings by the Chief Electoral Officer. Those were the positive elements. I
feel that there are two relatively neutral changes in the bill: the transfer of the commissioner into the office of the public prosecutor, the right to speak publicly with respect to an inquiry, and the burden of the obligation with respect to a person who is conducting an inquiry. The 54% ceiling being lifted, and the 25% also for contributions. These are neutral. But there are other changes that concern me and should be considered. Taking away the party expenditures ceiling, enshrining in the Act the right for the CEO to have direct documentation and communicate directly with all parties. And I also refer to the constraint of parties if this comes before the courts.
Were broached. The retention of the vouching process with the addition of obtaining written oaths, something that the bill does not foresee at the time. And the repeal of Section 18 of the bill to restore the Chief Electoral Officer's right to speak to Canadians and to reach out to disadvantaged electors, including youth, minority groups, and new Canadians. The confidence of Canadians in their electoral system must be maintained once this bill is passed, hence its very legitimacy. Thank you.
Thank you, sir. We appreciate the brevity of your opening statement because members are anxious to ask questions, and we'll begin those questions with the Deputy Chair of the Committee, Senator Baker.
Thank you, Mr. Chairman, and welcome to the witness here today, certainly an expert on the Elections Act. And I would, first of all, direct his attention and seek his expansion of a statement that he's given to the committee. The statement says as follows. Firstly, there is Bill C-23's proposed abolition of the legal provision whereby one elector can prove his or her identity through vouching by another elector. This will directly affect the constitutional right to vote of a significant number of Canadians, without justification, period. Now, Mr. Kingsley, that without effect, the constitutional right justification is important because, as Section 1 of the Canadian Charter of Rights and Freedoms says, you get to a point where a court says, well, okay, this violates the Charter, but it's saved by Section 1, is justified in a free and democratic society. You've said here it is not, that it is absolutely unconstitutional because it will deny a right to vote for a significant number of Canadians. Could you identify the numbers of Canadians involved and verify that you are concluding that it will not be saved by because it will deny a right to vote in one of the Charter?
Well, when I made the comment, obviously, I was keeping in mind the report that was produced, which identified 120,000 approximate number persons who were vouched for during the last general election. And the report that was produced, which reported so many administrative problems, irregularities, where a lot of documentation was not prepared. And I recommended two things in my remarks to handle this matter. The first one was get people to do their job. The deputy returning officers, the clerks, the people who receive people to be vouched. You see, one must understand what the process is here. I'm not talking about how you vouch. There's people in line, 20 people in line. They're all waiting to vote. One of them shows up with somebody else and says, I don't have my ID, but my brother's here, he'll vouch for me. Where are you? What's your name? Check the name, the names is there, the names are there, the addresses are there. Okay, you vote. I haven't got time to fill out forms. Now, in 2006, you'll forgive me for doing this, but I told the two committees, you needed additional staff for this. I recommended one additional person because the bingo cards were being introduced at the same time. All of that burden was put on the deputy returning officer and the clerk, no additional staff, same number of electors, all lined up. So therefore, we created a situation whereby these people have to move. The line's got to move. Canadians don't like to wait in line for a long time. I got phone calls if they waited more than half an hour. They'd call me up and be very upset. What kind of a system do you run? I didn't want to send them to vote in the States where it's 5 hours. So, I said, maybe we should fix the problem here. So the first solution is get the people to do their job. Now the Chief Electoral Officer, through his bill, will have the opportunity to appoint additional staff. The second one is the bill proposes in two cases where there's vouching now, where there's other forms of oath-taking, this used to be verbal, but there was a document prepared by the electoral authorities. The bill proposes that the oaths now be in writing as well, not just the documentation concerning it, signed by the person taking the oath. Well, there are two oaths that are taken when there's vouching, the person doing the vouching and the person being vouched for. The two of them should sign oaths, and that will solve the problem in one fell swoop. Those two measures together, you have yourself a solution to the vouching problem. You see, and I want to add one further thing, and I know I'm taking up your time. People forget that we have a system that was based on trust of electors until 2006. Then we changed the whole mentality and said, this is no longer good through the Accountability Act. We said, you need proof of address from now on. And not only that, you're going to need proof of identity. You're going to need proof of address. We want both. But we didn't set up, there's no federal authority that produces a document that's readily available with those two pieces of data on it. It's a form of inequity, and I relate that in my remarks as well.
So you're saying that the only piece of documentation would be a driver's license, but there's no federal issued piece of ID that contains a picture of somebody with their current address on it that you can rely on. In other words, you're saying that the vouching, as you probably are aware, in some court proceedings referenced in the previous hearing, Henry versus the Chief Electoral Officer of Canada, You're aware of that decision?
The BC court.
Yes, and the government of Canada based its logic on and said that the Elections Act was a legal document and requiring people to produce identification because the government of Canada said, we have the fail-safe of vouching. That was their position. Now, you have said that doing away with vouching will take away a significant number of Canadians' right to vote. So, are you in agreement that the next court proceeding on, if this passes as such, that it is entirely likely that a superior court in this country will strike down this provision in the Elections Act that we would be instituting if this is approved?
It's difficult for me to pass a judgment on what a court will do, to be honest with you. And frankly, any question which is preceded by if, I will be very careful about. I want the whole committee to know that. Okay. I don't know how a court would decide on a matter like this. What I do know is that a court would have to take into account there are Canadians who walk around without pieces of ID and address, especially pieces of proof of address. There are Canadians in rural Canada, in remote Canada, who live their lives as Canadians without all this paraphernalia that fattens my wallet.
Okay, Senator from.
I just want to thank you for being here. Senator Baker just mentioned that there is no federal piece of ID that has your picture on it and also your address. Can we make it clear you do not require picture ID to vote? Is that correct?
I'm not sure. I think that
You don't?
No, okay.
You don't.
I will accept that.
So it's not...
I never ran the system with ID.
I didn't really mean to put you on the spot.
I was very happy about that.
Although this actually speaks to, because Senator Baker's on the impression you need picture ID and you're not sure. No, and I heard you scrum the media outside and say you need...
You said there was no federally issued piece of ID with your picture and current address on it. Senator from Laura, go ahead.
If I said that, I take it back.
I think what we've just established is that Elections Canada needs to do a better job of informing electors, including Senator Baker, about what ID is actually required. My question to you, one question, just on the vouching. Vouching has been described as a safeguard. What is the safeguard on vouching? In other words, we know about the Neufeld report that was a compliance report, and that's when we found out that up to a third of vouched ballots had serious irregularities. We found that out through a compliance report, but we didn't. But is there a process after the election of verifying the vouching? How do we know if people are telling the truth?
Well, if you were to implement the recommendation that the oath be in writing, then you will have the voucher who's already on the list for that poll, okay, with the address.
Not necessarily.
Well, yes, he has to be at that poll, at the same poll as the person for whom he's vouching. We're talking about 350 electors at the most. There's only 350 electors at each poll, and they have to be from the same poll. So you would have that document, and he is saying, or she is saying, I know this person, and I know where he or she resides.
Okay, sorry, pardon me. The person being vouched for, it doesn't have to be on the list.
And all that would be in writing on those two forms, and the two of them would sign that oath,
and
saying,
then what happens?
I'm this guy, and she's that woman.
I understand, and then what happens? What if she's not that woman? How do we know?
Well, you have in scrutineers.
No, but how will they know?
Well, we can verify after the fact if there are people living there. I don't know if we do it. I never ran a system that had that. But it's something that could be easily implemented.
I think it seems that we don't do it, and it only came to light through the Neufeld report. Yeah. But it's not written into the process that part of vouching requires follow-up and compliance.
Well, if you wish to put that in the law, that's something that you can consider. If it's something that you wish a chief electoral officer should do, and you bring the chief electoral officer here and you tell him that you want that done. This is what Parliament exists for.
Sure. Okay, but we can agree that as it stands now, vouching is therefore very open to fraud because we don't do any follow-up verification. In the current system, it would appear. Okay. In your list of things, you listed that you're neutral on the spending limit increase. I guess neutral is good. Can you give us some context for personal contributions to elections by Canadians in terms of international norms? The number's going to go up to $1,500 per person. Or how does that fit into the world context?
We're the best.
Meaning?
We are one of the jurisdictions, or about one, that truly controls money in the political process, in the electoral process. Obviously, we could do better in terms of the auditing of party books, but that's another issue. In terms of the control of money, the fact that only a human being can give, who's a Canadian, the fact that that is an amount by which one cannot say that a politician can be swayed, or a political party can be swayed, that no corporation can give, no union can give, no association can give, not even the Boy Scouts of Canada can give. This is a tremendous system. And the fact that we've allowed third parties to exist, they could be the Boy Scouts of Canada, they could be Imperial Oil of Canada, and there are restrictions on what they can do in terms of money as well. We have one of the best. I hesitate to say the best because we're humble by nature, but I think we're the best.
Thank you for that. Okay, one last question, just quickly. So, do you have any issues at all with the provision in this bill that would allow fundraising costs to be deducted from campaign spending limits? Do you have any thoughts on that? In
my testimony, you may not have had a chance to review it. I say that is not that's impracticable because of the fact that you cannot go out picking up money without touting yourself or blasting the other person. You can only say, what can you say to someone? You've given to us before. You don't even have the name of the party on the sheet, because the moment you do that, that's called advertising in our system. You put out your placard with your picture, and we do have pictures on placards, and the name of the party, and that's called advertising. It's just there, it's sitting there. So if you send out a letter that has the logo of the party, give again, that's advertising. So you cannot divorce the two unless you sell a blank letter that says give again and there's no name on it. I mean, who are they going to give to? It's impracticable. It's not feasible. And the minister has said it's very little, and if it's so very little, then why bother, creating this loophole? Because I've always been concerned about what happens in loopholes. We get Brinks trucks and Garda trucks being driven through them, and there's no report on this. This is the other thing. We wouldn't know how much of this is happening. We wouldn't know what's happening over time. Is it, that small crack that's widening and it's going to let the tide in? That's the issue I have with it.
Sort of like vouching. Yes, okay, I got it.
Okay, Senator Moore.
Thank you, Chair, and thank you, Mr. Kingsley, for being here. I wanted to ask you a bit about robocalls, and I understand that this bill requires a CRTC to keep records for a period of time. I think it's a year. Is that correct? So what are the records that they have to keep?
Yeah. I think the CRTC has said in an explanation before the PROC, the committee in the other place.
You better explain what the PROC is. Because the
procedure,
people watching this or listening to it, they don't know what that is.
Okay, PROC is the Procedure and House Affairs Committee.
In the House of Commons?
In the House of Commons,
okay.
The place before which I appeared more than anybody else on the face of the earth so far. The CRTC has said that they would retain records for 7 years. Mm-hmm. The issue is there should be a congruity between how long they will keep the records and how long the commissioner can open an investigation that could lead to a prosecution. Mm-hmm. And I don't know what that is. It may be 10 years. It may be forever based on one change I've seen to the statute. But the real issue is that the texts of the messages will only be kept for 1 year, because the minister has explained that he doesn't want people who are not really engaged too much in the game to do that. And I'm saying 1 year is fantastic. Then what they should do is flip that over to Elections Canada for safekeeping, because they may be very helpful in terms of an ongoing investigation. There is just no way that all the investigations flowing from an election can take place within a year. And you would need access to these documents, and it would be very simple to simply say to the people who have those records, flip them over to the Chief Electoral Officer. Or to the CRTC, for that matter. I don't care.
Do the records contain the telephone number of the person contacted?
No, they do not at this stage, and that is one of the things I suggested should be done as well in accordance with Mr. Merin, because that'll help a lot, the investigators,
Certainly
to trace what has been happening here.
Section 2.8.3, enforce on day on which Parliament is dissolved. And I've read this a couple of times. I don't understand it. Maybe you can help me. Sections 4, powers and duties of the CEO, and 76 deals with voter contact calling services, and 137, 144, Telecommunications Act. All that comes into force on the day on which Parliament is next dissolved, or if that day occurs less than 6 months after the day on which this act receives royal assent. Those sections come into force 6 months after the day on which Parliament is next dissolved. What does that mean?
Sir,
let's talk in terms
I used to retain lawyers to help me understand stuff like that as well. I am not one of those. I do not know that. I cannot help you at all.
Can't help us at all.
Not at all.
Did you look at that section?
It was too long to look at in terms of all the... no, I did not look at that in detail. I gleaned over that one.
I'm trying to...
Because I know it's too convoluted for me.
Too convoluted.
Yeah, for me.
But it sounds like it's pretty important. It's coming into enforce day.
Yes.
So if it's a little convoluted for you, given the position you've held, how's this going to work for Joe Citizen?
Well, I'm sure that there is a common interpretation of that can be gotten from the people at the Privy Council office who prepared this text of law. And I'm sure there'll be witnesses here at some moment in time.
Yeah. Okay.
And I would lift my hat off to them at any time on this.
Yeah.
Senator Platt.
Thank you, Chair.
Thank you, Mr. Kingsley, for being here. We're spending an awful lot of time on the vouching, and there are many other parts of the bill, and Senator Frum has alluded to a few of them very well in some of the questions that she's asked. But I'm going to spend a little more time on the vouching, because that seems to be the issue that everybody is focusing on, and the opposition is. It seems to me that when they don't have proper arguments, they say it's not constitutional. That's the easiest way to argue any bill that has come before us. And we're going to have later on today a lawyer that will, I think, say it is constitutional, so I'm looking forward to that. Do you have any idea, sir, how many people needed vouching in the last election because they forgot their ID as opposed to not having proper ID?
I do not know that, sir. I did not study that phenomenon at all. Okay.
I appreciate that, and maybe there is no records.
The whole point of it is that there are no records. This is what is missing.
Well, there are records about the irregularities, that there were 50-some thousand that were pertaining to vouching,
right?
And I'm not sure whether they know this, but nevertheless, I may ask that of others yet. You did talk about in your testimony a few minutes ago about walking around without ID that has your address on it.
Yeah.
I walk around without ID that has my address on it many times, and before I asked the question, I went through my little clip to see if I had something with an address, and I noticed I did have my driver's license in there, so it does have an address on it, but many times I walk around. However, we don't just walk around and walk into a polling station. We go there for a purpose. We leave home for the purpose of voting, so it's not just walking around. So I would think that I would maybe, if I knew what kind of identification I needed, that I would maybe bring it with me as opposed to leaving it at home. And I guess that is why I asked the question about how many people do this by accident. I would think most people would take the ID required of them, and as the minister explained earlier today with the attestation, which in my opinion is a form of vouching. If I am the manager of a home care facility and the seniors there don't have the ID required, I can attest that they live at that particular place. So that would still be a form of vouching, would it not?
Well, I was at the back of the room and Mr. Merin was explaining, I think it was to Senator Frum, how that is a good idea, but getting people to act voluntarily on that front is problematic. If you were to put in the bill that they must provide those letters of attestation and not to do so would create an infraction, then that might become an alternative. But some people are just not willing to provide that. And you know, it's in some cases, it's also very expensive for them.
I appreciate that. However, to create a bill, because there are, and we need to make sure, I don't want to make light of that, we need to make sure that every individual in the country has their constitutional right to vote. But I would suspect that that number, when we talk about the 120,000 that needed vouching the last election, I would suspect that number would be considerably less. My last question to you is this, and I hate ever taking my information from the media, but I did read in newspaper article that you gave this bill an A- when it first came out. I'm wondering whether that grade has changed any since you first read it, and if so, were you a little quick to jump to an A-, or why the A- then and maybe something else now, if there is something else now?
Well, there is nothing else now.
So it's still A-?
There is nothing else now. And what I'm waiting for is to see what the changes are that through the various committees will be brought forth to the bill. And I've agreed with the media, some of whom are here, that once the bill is finalized and up for reading, I will rate it again. But in the meantime, there's no point in re-rating and re-rating. And every time there's an iteration by somebody else saying, are you still at A-, or are you looking at A, or are you looking at B-? It's not helpful to the discussion. There's some very important points that are being made, and I don't want to take away from them from the various people by saying, okay, as a teacher, I'm now at B+-. It doesn't work that way.
Through my life, I was usually happy with a B+.
I know.
Senator Batters.
Yeah, I was always happy with an A- as a midterm grade. So I guess we'll see. Well, true, but A- is pretty good. I wanted to just direct you to, because I appreciate the fact that you shortened your opening statement to conform to the time we have available today. So there were some parts of your opening statement that you handed out in writing which you didn't have too much time to get into. And I certainly can see from the number of points that you made listing positive elements of the bill, and then there were a few neutral ones and a few areas of improvement. I can certainly see how you came to that assessment. But one I wanted to talk about was the Director of Public Prosecutions issue. And my past experience was as the Saskatchewan Justice Minister's Chief of Staff. And in that capacity, although the Director of Public Prosecutions for Saskatchewan technically reports to the Minister of Justice, independence for that office is vital, and it's a very well-respected tenet of that office from the Minister's office. And I see that as directly translating to this situation here, and I'm just wondering how you would comment on that.
Well, I read that section of the bill quite thoroughly, and I've put that in the neutral side.
Yes.
And there were several relatively small concerns which I raised, and I'll raise them again. But the independence of the Director of Public Prosecutions exists under our system, even though theoretically, and in reality, she must meet, it is now a he, with the Attorney General, because that is what is required. What is not known, and I've not heard it anywhere else, is that whenever it is an infraction under the Canada Elections Act, the Director of Public Prosecutions cannot discuss that with the Attorney General. That is an exception that was made, that was obtained when I testified before various committees on when we were dealing with the Accountability Act. So, but even if it were not for that, we still trust the DPP, the Director of Public Prosecutions, if there is a criminal infraction perpetrated by a political party or a politician of any ilk, but not under the Canada Elections Act, we still have faith that he will go ahead and prosecute this in fairness. That has never been an issue. And the process by which we choose the DPP is a very thorough process. So that is why I am satisfied. Now, we heard the Chief Electoral Officer talk about the need to set up mechanisms so that there can be discussion. I would say that one thing that we should consider is having the Director of Public Prosecutions, having the Commissioner, the right to speak during an election about certain inquiries when it is in the public interest that he do so. Right now, he would be prevented under this bill. And I know how reluctant politicians are, to see someone who's in charge of investigations report that an investigation is going on in this particular case, not only during an election, but it's worse when it's an election. So that's why we always adopted the policy when I was there, which I think is still there, which I'm sure is there, that we don't comment on investigation. But sometimes, we simply cannot say to a commissioner, you can never talk to the people. Because he or she may uncover, and I think you were alluding to this a short while back, he or she may be coming across something which it is in the public interest that it be made public. These are things that happen during an election in this country, and it would be helpful. This is what I meant in my statement when I said the trust of Canadians must be maintained. They must know that their people running the system are able to talk to them when something wrong is happening. We don't know what that would be.
Okay, we're moving on to you now.
I was just going to supplement. See, part of the problem with that is that you're innocent until proven guilty. And so what happens, a candidate's out there running, thinks he didn't do anything wrong, and all of a sudden there's a headline covered across the country that this person has done something that we believe is incorrect. And so what will happen is the commissioner who will do the investigation will turn it over to the Director of Public Prosecution. They will make that determination. So if you do it the other way, and trust me, when it hits the media, you're guilty. And you've got to run a campaign. And that's the problem, and that's why I agree with the way the legislation is now. But I want to get on to some other things, and I don't have anything too heavy here. I appreciate your remarks, and thank you for coming. The matter of voting, which I think is constitutional, the fact that what we're doing, is a problem. There's no doubt about that. And part of this, it's a funny thing about change and people adopting change. It takes time. And just as it is, that one has to, provide information when you go vote. You have to provide information when you exit the country. You have to provide information to get a health card. You have to provide information for everything. Education will bring this around, and practical experience will bring this around. And I leave that with you, because I do believe it's a matter of practice. And goodness knows there's enough advertising in election campaigns. If a person doesn't know that the election is on such and such a day, trust me, I don't know where they've been. The other thing I want to point out is that, and I'm not sure if I understood what you said with respect to fundraising expenses. Elections are very costly, extremely costly, and my experience with those that run elections and run fundraising campaigns and so on, hold on to those records. And particularly, ones that, whether it's duplicate, they're going back a second time or whatever, they are extremely cautious on expenses. And I happen to agree that this should not be an expense. Anyway, that's for what it's worth.
Okay.
You can comment if you like, but...
Well, I appreciate the expression of your views, sir.
All right, well, I've exhausted the list, and we still have some more time, and we have a visitor to the committee, Senator Ringett. We'll give you the opportunity.
Well, thank you. Thank you for being here, and I just came back from a mission in Peru, and because of the this bill that is of high importance to most Canadians. I've inquired about their election system. The government there provides a picture ID free of charge to every citizen, and it has a chip. So, which brings us to the fact that if one party wants to have, and I'm not talking about a political party, if one entity wants or requires certain ID, shouldn't that party also be responsible to provide it?
That is the position to which I was alluding when I said that there is not one federal authority that provides in a readily available form proof of ID and proof of address. And when you talk about Peru, in Mexico, they provide you with an electoral card that has your name, your picture in holographic terms, your signature, a 12-character alphanumeric code, your fingerprints on the card. You don't bring that card to the polling station, you don't vote. But it is the electoral authority that has the responsibility. It is called the Padrón, and they have instituted this since they started it in 1992, put it in place at the election in 1994, and the Mexicans have been holding excellent elections since then.
Okay. So, which brings me to what I was trying to make my colleagues understand here, is that when you put a requirement, you also have to provide the mechanism to meet that requirement to your citizen, and this act doesn't seem to provide it. So maybe that the intention of the bill might be right in regards to voters, but it should be. It should come after that an ID national mechanism to all citizens is put in place. And we have countries that have seen that light.
Right.
Move on to Senator Frum on the second round.
Just a follow-up to that. It matters that we have a parliamentary system with representation by riding and by region. And so, unlike other systems, it matters where you live when you vote. You have to vote in the riding that you live in. And that's why I would think, and my question to you is, that's why this problem of a national identity card doesn't solve our problem here in Canada. Well, you didn't say that. But the problem with that becomes, but then you're into all the same difficulties of people who move. I'm not saying I'm opposed to a national identity card, but I'm just saying that the significant feature and factor is not your photo, and it is your address in our form of parliamentary democracy.
Right. And Senator McCoy has attended today. Would you like to ask a question?
Thank you, Chair. Thank you for the acknowledgement, but no, I have no questions at this time.
Senator Baker?
Yes. Just for clarification, Mr. Kingsley, you said in your prepared statement, not in your verbal statement, but you said that, and I quote, Bill C-23 would certainly provide longer reach and sharper teeth should the authority to compel testimony be granted to the Commissioner of Canada elections. This is the authority that the Auditor General would have of Canada in the Act to have the authority of a commissioner under the Public Inquiries Act. This would be the same authority, as I understand it, that's held by several jurisdictions in Canada, provincial jurisdictions. And it's probably, would you say, the reason why the commissioner has not been able to proceed adequately with investigations that were presently underway concerning the robocall matter, and other matters. Is that your point?
That is the point, and I think that the Chief Electoral Officer, not here but elsewhere, indicated that, and I allude to this in my remarks, people now know that they do not have to talk to the investigators at Elections Canada, and they may have very pertinent information. That is not incriminating to them, but it's just the fact that, they would have to be talking about friends or people. They refuse to do so. But if the authority, which can only be gotten through a court order, by the way, and I think this is a point that was missed in the earlier conversation, only through a court order, which is an exception to what the other federal regimes have. They don't require a court order.
That's right.
Here it would require a court order in the proposal that has been made. And so for that reason, we stand the chance of never knowing what really happened in robocalls.
Because of this?
Because of this.
Because this requirement is not in the Act.
If we had this, I'm 95% certain we would get to the bottom of it.
Why wouldn't the government do it? You're no longer the Chief Electoral Officer. Why wouldn't the government do it?
Well, the explanation has been provided that the relationship is with what a policeman has as an authority in a country.
Officer. Yeah.
Well, that is what has been offered, sir.
Yes.
Okay.
Senator Rive, you had a question?
Yes. I just want to make a general remark. If I recall, with respect to the National Assembly in terms of election law, they try, at least that's the practice in Quebec, before bringing in a bill to obtain a consensus from the political parties with the participation of the people at Elections Quebec. Now, we see that we're involved in a parliamentary game here with this bill. In your experience, wouldn't it have been perhaps more useful for the government to bring in Elections Canada with a representative of each of the parties and try to reach some sort of consensus on the changes that were to be made rather than just bring it in a government instrument? Well, I've heard both sides of these issues from ministers, from the side of the Chief Electoral Officer. Would it have been improved? I don't know. Is it a matter of the minds of the people who want to accomplish something? I don't know. I don't know what it would have been. But I know it's often been the practice. It happened to me when I was there, that there were bills that were brought in without necessarily having a warning sent to my office. It does somewhat provoke matters.
Kingsley, thank you very much. You have one final comment?
Yeah, I wanted to say the suggestion that was made with respect to vouching, I made the recommendation that it be in writing. And the idea is floating around that maybe there should be more knowledge and so on and so forth. Why don't we try both? Why don't we get the Chief Electoral Officer at the next election to mount a massive campaign about getting your pieces of ID together, and then see how that reduces vouching, but don't eliminate it. Try it for one more election, and then verify what happens. See by how significantly you can reduce it by doing that type of thing that is being proposed, instead of just eliminating it one fell swoop. A suggestion for you.
All right. Well, thank you for the suggestion, and we appreciate your contribution to our deliberations.
Pleasure.
Much appreciated.
Merci.
Members are going to recess for a few moments before hearing from our next witness.